How is assault and battery defined in California? Attorney Lawrence Wolf explains that assault and battery are two different charges. However, most people think it's either one charge or that you must commit one before you can commit the other, but they are actually two separate charges. The definition of assault is some type of threat or exert force. Battery is the actual exertion of that force. You can commit an assault without committing a battery, and likewise, you can commit a battery without first committing an assault or making a threat. A simple assault, or a simple battery, is an instance where there is not significant injury or where no deadly weapon is used or there is no amount of great bodily harm. Basically, both charges are going to depend upon the extent of the injuries. Obviously, in an assault case, there are no injuries, so it's going to be judged by the extent of the assault. If someone says, "I'm going to bomb the Dodger Stadium," that is obviously far more significant and serious than the individual who says, "I'm going to punch you in the nose." Additionally, a wobbler charge is a crime that can be charged by the prosecutor either as a misdemeanor or as a felony. In other words, as with the previous example, the extent of the threat or injuries is going to indicate what the prosecutor decides to file, whether they decide to file it as a misdemeanor or a felony. A wobbler doesn't only apply to assault and battery cases. It applies to numerous penal code sections. Call now for a free phone consultation by contacting Lawrence Wolf, attorney at law in Los Angeles, at 310-277-1707, or visit his website at www.youareinnocent.com.